All right, you guys ready to get started?
Let's do it.
Let's fire away. First, let me thank our panelists for joining, and all of our guests for joining in this NIL collective discussion. We're going to go about an hour or so, joined by three esteemed NIL experts. I am no expert, just a lonely reporter. I would give you a little bio on each, including myself. I've been with Sports Illustrated for about 4 years or so as a national college football writer. 3 of the 4 under NIL. It feels like it's kind of I've been an NIL reporter, I feel like, for the better part of 3 years, especially the last year. And all 3 of these guys on the call actually have been really helpful in understanding NIL. So let's go first to Peter Schoenthal, an attorney at Athliance, a software company in the NIL space specializing in data, compliance, and education for schools, athletes, collectives, agents, and at times reporters, because he's been very helpful. Mitt Winter, the head of the sports law group at Kennyhertz Perry, LLC in Kansas City. He is an expert on NIL matters, an expert on NCAA bylaws. He's been involved in some actual cases like the Ed O'Bannon case and the Alston case. And Mitt, most notably, is a former Division I basketball player at William & Mary, where he still holds the home record for points in a game. And then Michael Caspino is an attorney based in Newport Beach, California, and he specializes in representing athletes in NIL deals. He's the most popular one on the call, and certainly the guy that everybody is here to see and listen to. So thanks for the panelists for joining us. And again, the guests, as you start coming in to our panel here, please know that there's a Q&A button on the bottom right of your screen where you click it, and then you could write in there a question and answer. And at the end of our discussion, we're going to try to get to all the questions that we can. So I'm going to kick it off here by, talking a little bit about what we're going to talk about, which is not just NIL, but specifically collectives, what they can do, what they can't do, what they are. I feel like I've spent the last year or so trying to understand collectives, how they work in the space, and clearly they are a huge part of this NIL evolution, which has gone from brands and businesses involved in NIL to boosters involved in NIL and forming collectives. So it's been interesting to kind of get in the weeds on collectives and try to understand them. So I'm going to throw kind of the first question out to the group, and that is, can collectives, and this is a question that we all have, and it's been debated about a lot. It's, can collectives enter deals or broker deals or have discussions about deals with high school athletes? So basically a collective's role in recruiting, what is it? Are they allowed to do it? And Mitt, if you want to start, and we'll kind of go down the line and just talk about it a little bit.
Thanks, Ross. In my opinion, if the collective is following the NCAA's NIL policy and the guidance that they've put out after they issued that policy, the answer is no. Based on that memo they put out in May, it was pretty explicit that the NCAA is going to consider collectives boosters. And under the NCAA rules, boosters are not supposed to get involved in the recruiting process. So I think it's pretty clear, at least my understanding of the rules, that the answer is no.
Yeah, and I'm going to second Mitt on that, but I think it's important to kind of go down a little bit of a journey. One thing I always hear is the word inducement. First off, inducement is a weird word because recruiting by nature is an inducement, right? I'm trying to induce you to come to my school. But one of the things that we hear a lot as it pertains to challenging whether or not collectives can, in fact, broker deals or discuss deals with athletes is Alston, right? A lot of people say the NCAA is dead, they have no governing power. But Alston really had to do with educational and non-educational benefits. And I think it's really important to note that those benefits are the benefits that come from the universities. Money and deals that collectives broker with athletes has nothing to do with non-educational benefits. And so, you know, I think it's important to note also what came out of Alston, which is the following. The NCAA is a governing body whose purpose is to effectuate competitive balance through uniform rules, so long as those rules are reasonable. And by the way, when looking at whether or not they're reasonable, there's some antitrust issues. But I think limiting boosters and non-affiliated members from partaking in the recruitment is reasonable. And I personally don't see any strong antitrust issues there. And I think it's important to note with collectives, as they start to form as marketing agencies and do advances, it's the old phrase, you can put lipstick on a pig, but it's still a pig. Collectives, for the most part, are boosters or supporters of a particular school that are doing most deals with athletes at a particular school. The real value is if the kid is at the school. I mean, most of these boosters are using colors, logos, and names that are tied to the school. So they obviously are there when dealing with the recruits, the purpose to get them to a university. So if there isn't antitrust issues, and Mitt alluded to it earlier, it's all about that interim policy, right? And so we have the booster definition, which pertains to promoting the institution's intercollegiate athletics program or assist, and assist student athletes. And when you get into collectives that are boosters, I mean, I think bylaws 13.121 and 130214 are very clear. I mean, NCAA rules preclude boosters from engaging in recruiting activities. Recruiting conversations between individuals or entities are deemed a booster are not permissible, can't really communicate, can't promise deals. And so when you start to look at that, you have to be careful. Now, the one thing I think we could see is if the NCAA does come after a booster or a collective, you have to be very careful, because if they do bring that lawsuit, step one is discovery, which means all of emails and text messages are being turned over. So I always warn coaches and people within the athletic department, be very careful with the conversations you're having with boosters and collectives, because if that case ends up in court, which I think the NCAA would win, all of those conversations are coming to light. So be careful.
I think that's a really good point that you raised, Peter. And I think it's one reason that if the NCAA does enforce its NIL policy against a school or a booster, I think a booster would think twice about suing the NCAA because of what you just raised, because of the discovery. You know, if you're just talking about an NCAA investigation, the NCAA doesn't have subpoena power. They can't conduct discovery. They can't do depositions. They can't serve interrogatories. They can't serve document requests. But if it's a lawsuit, all that stuff's going to be available, and all that information will have to be produced.
Ross, I take a little bit of a different approach, respectfully, with my colleagues. I'm sorry, but the more I read NCAA materials and guidelines and manuals, the more confused I get.
Join the club.
This is a mess that was created not by any of us or the athletes. It's a mess that was created by the NCAA. They decided 20 years ago to fight at all costs compensation for athletes under any circumstances. They lost. Now we're in havoc. Now we have all kinds of different rules. We have all kinds of, there's questions about whether the rules that exist today can even be enforced. You know, I try to read this stuff very carefully, and I read the interim guidance that just came out a couple months ago, and it talks about prohibiting improper recruiting inducements. Is there a proper recruiting inducement? I'm trying to figure this out. And when I read through this, it's more gray than I could ever get. A booster / NIL entity may not communicate with a prospective student athlete, a prospective student athlete's family, or others affiliated with the prospective student athlete for a recruiting purpose, or to encourage the PSA's enrollment at a particular institution. So then I say, okay, so what if the kid does a verbal commit? I'm going to the University of Micronesia So then can the booster and NIL speak with the kid because they're not talking about recruiting anymore?
So Mike, I'm going to chime in there because in the world of recruiting, though, just because a kid gives a verbal commitment doesn't mean that their recruitment is shut down or that they don't have the ability.
But let me stop you there for one moment. If we go down to the bottom paragraph, it talks about before a PSA signs a national letter of intent. So we have two separate standards. They're not saying you can't speak, you can't start speaking to them once they sign a national letter of, or until they've signed a national letter of intent. And they certainly could have used that as the bright line barrier, but all they say is for a recruiting purpose. So we have to climb in the minds of the people who are talking to this athlete to figure out their intent. Boy, that sounds easy. That sounds doable. So, I mean, what they're saying is a collective can communicate as long as it's not for a recruiting purpose or to encourage the student's enrollment at a particular institution. So if I'm a collective and I want to buy that kid's rights, but I'm not doing it for a recruiting purpose, it's okay, right? I don't know. These rules are so gray, so twisted, so contradictory. We don't have any real guidance here. We really don't.
Mike, I do agree with you. That's an issue that needs to be clarified. And I guess that's going to have to be clarified by the NCAA when it does start doing some investigations and some notices of allegations. Where is that point? I mean, because collectives can talk to the athletes, but when is the question? Is it after they verbally commit? Is it after they've signed the letter of intent? Is it after they set foot on campus? I agree that is gray area right now.
You see,
let me try one more thing. So we all agree with the premise that a student athlete may be compensated for their name, image, and likeness. But in determining going to a certain school, they're not allowed to ask, what can I potentially earn at this school? That's not allowed.
I don't think so, but I want to go back to your previous point. And the interim policy really talks about PSAs, prospective student athletes. I don't think until you sign that letter of intent, you go from a prospective student athlete to a non-prospective. Now you're a student athlete. So my argument would be, especially, listen, I would err on the side of caution with this stuff, especially if I'm a university, that the intent of this piece of legislation, the interim policy, that trigger on when people and collectives can speak with student athletes or PSAs is once they sign their letter of intent.
And my position,
yeah, I agree. That's a safe course of action.
Yeah, my position is that, the NCAA is a whole bunch of smart people with very smart lawyers. Why are they being so obtuse? Why are they being so unclear? Anybody having a thought on that? Why?
Probably because they're scared of getting sued again and losing in court. Yeah, if I had to guess.
And I agree with that, and that is an issue. And I think it's really time for the NCAA to kind of draw a line in the sand, clarify certain things, and they're going to listen, if people are going to sue them, that's part of running a big organization. You have to be a little smarter with the cases that you set yourself up for, make sure you're not setting yourself up for failure. And weirdly enough, as it pertains to collectives and high school recruitment, I think this is one of their strongest positions as it pertains to what came out of Alston, other antitrust issues, and competitive balance arguments.
Well, as Mitt said earlier, and Michael, I think, alluded to it, we're not going to really know answers to some of these questions that we're asking until it's enforced, right? Until the NCAA does an investigation and actually cracks down on something. And the problem with the NCAA doing that, right, is the fear, and I think the reason they haven't done it is the fear that they'll be sued and they'll lose in court, because how do you prove something was an inducement, right? And that's kind of the key question here is, how do you prove an inducement? Like Michael mentioned, ex-recruit, entering a deal with a collective, and although that collective, is not affiliated with the school, but obviously in a way represents the interest of that school, if they enter a deal with that collective and end up going to that school, how do you prove that it was because of that deal they entered? I guess that's kind of the question, right? And it's very hard, right? It's very hard to prove that this was why this was the inducement, so to speak.
I think, yes, if we look at it within that vacuum, but if we also look at already pre-existing rules as it pertains to boosters and interactions with PSAs, I think that has been fine lined, and I think that is established, and I think that's where the NCAA could hang their hat on in some of these lawsuits.
Anybody ever wonder why they keep issuing guidelines and guidance and not rules? Anybody ever wonder why?
Hey, I'm scared of getting sued, Michael, right? They had this, they spent 2 years on this NIL policy with all these guardrails and prohibitions and all this stuff, and they threw it out the window after the Alston case because they knew if they implemented it, right, they would be sued and lose in court.
Even though it's called an intern policy, I mean, to me, it's still rules, no matter what you call it.
Yeah, and listen, we're all figuring this out. I think if anyone saw collectives coming day one, that they'd be a genie at this point. This space changes so much, and I think it's really hard to have these fine set rules that you don't change. I don't listen. My mother always says, "Don't rationalize irrational people." So I don't know if the NCAA did this on purpose, but I think there was this, and maybe it was forced because of Alston. Let's sit back, let's see how this space plays out, and then let's go and codify it and have a space that we can all operate under. But I think that doesn't happen until there is some form of infraction put out that shows, hey, we still have power. We're not afraid to do that, and everyone needs to start playing by the rules. And I think it was okay to let the space play out, but I think it's time now. And I think people are clamoring for whether it's, I'm going to broker deals with high school athletes or I'm not. I think people want guidance. Like, let us know what we can and can't do, and let us move on.
Yeah.
Isn't that kind of like issuing speeding tickets, but you don't post the speed limit?
I think that's an extreme analogy, but I see where you're
going. I don't know. I mean, this is the fact that they won't clarify all of these crazy guidelines that they put out there and give us a set of bright line rules. It's so unfair to the prospective student athletes.
Well, maybe it's coming with enforcement. I mean, we all know about 6 weeks ago, and we were one of the outlets to report, that Miami was under an inquiry by the NCAA, and they were meeting with their specifically one booster down there and a few other people. And I was just down in Miami, happened to be for a story a couple of weeks ago, unaffiliated with all this. And I was made aware that they're still interviewing people. So maybe we'll see something happen there that will clarify the rules. I don't know. I don't have faith in that, but who knows?
I think, Ross, you made a really good point. Even if they try to clarify the rules in some fashion, proving that something was an inducement is going to be hard in any case, unless there's some smoking gun, like a text that says, I'm committing to X school because of this NIL deal, or an athlete admits when he's being interviewed by the NCAA. Other than that, it's going to be circumstantial evidence, which is, hard to prove anything.
And I know at the end, we're going to talk about like what we'd like the space to look like. And we all have ideas on what some of those rules can look like. But I think in the meantime, that's why it's so important, in my opinion, to have a bright line rule on one way or another what you can do before a student athlete signs a national letter of intent. I think that's what people want to know. And I think you're 1,000,000% correct, Mitt, and Mike, on what is an inducement? Are they inducing? I think it's going to come down to, if you're a booster, you just can't really be in contact with a PSA, and we're going to have to figure it out from there. Or let people be in contact. I just think we need a bright line rule on that as it pertains to signing your national letter of intent.
I think right now the safest course, like we talked about, like I agree with you, Peter. Collectives / boosters just shouldn't talk to PSAs right now.
All right, we're gonna move on. That was a fun discussion. Let's have another on a different topic. And Michael, you have seen a lot of NIL deals made between a collective, right, in athletes. Can you take us inside what these deals look like? The good, the bad ones? Just give us an idea of what they look like, these contracts with athletes and collectives.
Bad ones take advantage of the athletes. There's contracts I've seen where it's a loan that can be called back at any time. There's contracts that I've seen that attempt to financially bind the kid even into their pro career. I see all kinds of crazy stuff that's out there. My biggest worry in this entire process is how the students are treated. Most of my clients don't have the money to get an attorney, don't have the money to go through this process with people by their side to help them. So I've seen a lot of very, very bad deals. The good deals, those are the deals that are in writing. Those are the deals that are agreed to between the parties. There's a mechanism for enforcement. Everything is laid out just like any other commercial type of contract is put together. Those are the good deals. And those are what the good collectives are doing. But I've seen everything in between. And the exploitation of athletes is really, student athletes is really my passion to fight here. But that's what we see.
Yeah, Mike, I think that's a great point. You know, one of my biggest issues in this space is we have a bunch of state bills, and we know the state bills mean nothing. Because if you're the state of Florida, what is your reason for going after Florida State, Florida, Miami, if you know other schools in other states are doing similar things? You're not going to go after the athletes. But one of the things, not only with collectives, who a lot of them are working as marketing agents, so they should be registered as agents, but also agents, is we're seeing that these kids are signing bad deals, getting taken advantage of by their representation. And these state bills, they talk about protecting the athlete. My biggest issue is, why aren't any of these states regulating the agents, making sure that they're registering with the state? If they're breaking any of the rules that are put in place, going after them with financial fines. To me, that's the biggest issue with the space, is these kids are not getting fair and good representation, and they're getting taken advantage of in just another way.
I agree with that, Peter. If people talk about they want some certainty in this space, a lot of the state laws are pretty certain on what you can and you can't do, and they're just not being enforced right now. If somebody did really want to bring some certainty to the space, someone could start enforcing the state laws. But like you said, what incentive does the state have to do that? It's really just going to be harming state U, and whoever starts to enforce it probably won't get reelected. So chances of that happening are probably not good.
But Mike, we've seen a lot of deals, and you made a good point. A lot of these deals, especially under the states that have the rules where the deal's supposed to end at the end of eligibility, we're seeing these deals that go on in perpetuity, that are much longer. We're seeing certain, I don't want to say collectives, but agents taking 30-35% commission. Right. It's crazy. And now we're starting to see a lot of these terms leak into these collective deals, where I don't even know if the collective realizes how badly they're taking advantage of the athlete. They're just copying some of these other contracts they see, and that's a huge problem.
Yeah, I mean, these contracts are very, very complicated. They take a lot of time to put together. To do it right, you got to make sure it's NCAA compliant at all levels and state law compliant. So they're tough. And I think there needs to be some form of legislation allowing for attorneys' fees to be given to the kids, an allowance for that, so they can get the proper advice.
Yeah, and Mike, you and I had a talk online. We've seen a lot of deals that have the frustration of purpose, right? I really think there's going to be a situation where an athlete has a deal with a collective, the athlete transfers, and under that frustration of purpose, a collective is going to try to get out of that contract. An athlete's going to file a lawsuit, and now we're going to get into pay-for-play and enrollment issues. And I think that's kind of the first lawsuit that we can see as it pertains between an athlete and a collective, where we're really going to get to look under the hood as to what happened as these deals were put together.
Yeah, there's four ways these deals can fall apart. Okay, number one is the kid's a flop, right? And there's a big problem, and they're still paying him and the rest of that. I get it. Second is injury. Third is a conduct issue. They hit someone and it's on TMZ everywhere. And the final one is they decide they don't want to be there anymore. They want to transfer. All of those are probably going to happen over the next few years. We're going to see how it plays itself out.
Yeah, because we know some collectives are going to try to get out of those deals, and that's going to be problematic.
Yeah, I think there will definitely be some litigation between athletes and collectives in the next few years, for sure.
And I wonder if some of these bad deals, I'm curious if some of these bad deals, you guys know, you've heard from college administrators, right? They nonstop, and today I saw at Big Ten Media Day, Kevin Warren said it, nonstop say, we need Congress, we need a federal NIL solution, we need help from Congress. And I wonder if you get enough of these bad deals where it's been exposed that athletes are being taken advantage of, then does Congress start paying attention? I wonder if that triggers Congress.
I hope something does, but it would be a shame that we have to wait for a bunch of athletes to get taken advantage of before anyone decides to do anything. And that's the problem in this space, whether it's the NCAA, Congress. We're being so retroactive rather than trying to get ahead of this and make the, what's really interesting is we hear all these horror stories. The beautifulness of NIL is actually happening in front of our eyes. It's just happening in the FCS D2, D3 level while we sift through the BS on the Power 5 level because we can't get our ducks in a row as a community as it pertains to the rules and having true guidance on them.
Even if there is a federal law that gets passed, I think the challenge is still going to be enforcement of that law. Or is it going to have an antitrust exemption that allows the NCAA to put in more restrictions, but then you still have the NCAA enforcement issue. So I think with everything NIL, enforcement is going to be the problem at the federal level. Who's going to enforce it? Are they going to be able to police all of the deals that are going on? So enforcement is just the biggest issue.
Nate, is this where you plug collective bargaining? Is this your time to plug it?
I think it's going to has to happen at some point. I think it's the easiest way to bring order, not just to NIL, but just to college sports in general.
I mean, that's what the Supreme Court said in Austin. Your best chance of avoiding all of this is just go collectively bargain.
Yeah, if you're able to sit down with athlete reps, NCAA conference, school reps, whoever, agree on what the rules are. Everyone knows those are the rules. They've been agreed to, and they're exempt from antitrust law if they're collectively bargained. So you don't have to worry about the lawsuit issue anymore. I just think it's the most orderly way to do things. I understand why the NCAA conferences and schools are not really in favor of doing that right now, but I don't know. I think they'll see the light at some point, either just by agreeing to do it themselves, or NLRB is going to declare the athletes employees, or Johnson or another case will make that decision for them as well. So it's just a question of, do they do it voluntarily or are they forced to do it?
I tend to agree. I think the writing's on the wall. If I were the NCAA, I'd start contemplating it and start trying to get what we want. One of the reasons why the NFL owners always get what they want versus the players, it's not billionaires versus millionaires. It's 32 collective individuals going against 2,500 athletes of different statures and care levels. And I think we're going down that road, but from an athlete standpoint, I do worry in that there's going to be a big issue trying to come together, have a collective goal, get what we want. And it could be scary, but that shouldn't be a reason why that shouldn't at least be discussed as a potential.
Yeah, it'll be hard, as we've seen with the CFBPA stuff and the Penn State and the Big Ten stuff over the past few days. It's going to be hard. There's a lot of college football players. There's a lot of college football teams. Not everybody feels the same way on the issue. It's going to take a lot of time and manpower to go out and try and organize all these athletes to get on the same page. So it won't be easy.
I hate to say it, but again, I kind of counter respectfully my esteemed colleagues, but I think the havoc we're seeing is the new normal. I can't see everybody getting on the same train with collective bargaining. I can't see a congressional exemption for antitrust. Let's face it, there's a huge race component here, which was acknowledged by Justice Kavanaugh in his concurring opinion. I can't see Congress getting behind that. I just think this is going to be the new normal, what we're in, and we need to get used to it.
Michael, you rep a lot of athletes. I remember talking to you a couple of months ago, and it was like 200, right? I mean, has it increased? Where's your client list at as far as numbers of athletes that you represent in NIL?
Well, it's in the three figures, but we've had signing season and people, doing their thing. So, it's maintaining steady, lots of interest, it's a flurry. It gets busier and busier every day. There are more players jumping into this field on the collective side. That's happening every week. Every week I get astonished that, wow, that school has a collective now. That school's in this. And it's not constricting. It's definitely growing quickly.
I was just talking to a management company who kind of manages collectives, and he said, as he had expected, pretty much every Power 5 program has at least one collective. But he also said that the group of fives are starting to pop up, and he's seeing collectives at the group of 5 level which surprised me because the resources obviously in the group of five are nothing like they are in the Power Five. But it seems like everybody feels like they need a collective, right?
Well, Ross, we're starting to see it on the D2, D3 level and the FCS level. And I think on those levels, from what we see, since we handle a lot of the compliance and disclosures, is you're starting to see team specific ones. Like, I don't know if it's been started yet, but like at Johns Hopkins, right? They're not a big athletic department, but man, do they care about their lacrosse. I wouldn't be surprised to see a Johns Hopkins lacrosse collective pop up. Now that brings different Title IX issues and many other issues, but I think that's coming. And we're also starting to see a whole bunch of different structures as it pertains to collectives, whether it's agencies, whether it's crowdfunding, crowdsourcing, all that good stuff.
Ross, one thing you mentioned is, traditionally we think of the group of fives and FCS or whoever not having as many resources as FBS Power Five schools. But when you're talking about a collective, it's different than the resources that an athletic department has, because most athletic department revenue is coming from TV deals, which the smaller schools don't have. But an FCS school, D2 school, D3 school even, they could have some very, very wealthy boosters. And that's all you really need for a collective. You don't need to have a huge TV deal to have a collective that has a lot of money that can do a lot of deals.
Yeah, and kind of the hint today has been like collectives can be doing bad things. There's so many collectives doing great things that are structured the right way, that are doing things the right way, where they can really be a blessing to an athletic department or a team if done the right way, and you have people running it who want to do things the right way. I think collective is such a scary word, but it's not one size fits all. And I know we were going to talk about collective structures, but there's good ones and there's bad ones for sure.
I'm so interested in all these, Michael, all these right new agents are coming into this field and new representatives and stuff. And I'm just curious of how their arrangements are. You would know. I mean, you're kind of one of them. You represent athletes. Like what are the arrangements like with agent, athlete, collective? Who gets paid how? How does it work?
I have seen so many of them, and I saw one yesterday. It was 12% is what the quote unquote agent is getting, who I think was like a 21-year-old kid. And I see ones where people are getting 30%. And I'm just looking at these folks and saying, how, what are you doing here? What you're taking advantage of these kids. I mean, there needs to be some kind of legislation to protect against this. So I get it all the time. Typically, by the way, I'm by far the oldest guy doing this. So, but most of the guys I meet who are doing it are, young enough to be my kids, and they screw up the deals. They have them sign stuff that's not NCAA compliant. And, to become an agent in the state of California is not a very high barrier, very small, very low, like no felonies, and you can get it, and that's about it. And anybody can become an agent and run around. And I was at the big 7-on-7 tournament in Vegas a few weeks ago. I saw all these young guys walking around trying to get kids to sign on a clipboard. It's a disaster. It really is.
Mike, I have to second that. We see a lot of contracts come through. And one of the things that scares me to death is the amount of agents and big named agents that we probably all know, if I said it on here, taking 30% from these kids, taking fees as it pertains to, let's say I'm taking 30% on $1,000 deal. I get the $1,000. I take my $300 and my expenses, which you can't ask accounting on, and then I pay you out. It's crazy on that end. And again, it goes back to what I said earlier. These state boards have to get involved. They actually have the power to regulate this, and they're not doing anything, and that's a shame.
Mike, is your situation like what? What is your normal arrangement with players and collectives and all that?
With me, I've never taken a penny from a kid, not a single penny. So what I do is I kind of do the European sports way, as Pete and I were talking about before, is I take my fee, which is typically a couple points. That's it. And I get that from the collective paying me for my legal work. And all the appropriate, of course, waivers are done. But I've never taken a penny from a kid. Never. I take it, the collective or whoever we're doing the deal with will pay my bill.
Collectives in their future, right? As there's a lot of, it feels like there's a lot of threats to a collective's future. The NCAA, for one, investigations, we talked about that a little bit, the sustainability of continuously generating donations, generating dollars from boosters year after year, in athlete employment, in collective bargaining and revenue sharing, like we mentioned. There's a lot of threats to collectives. So one question for the panel, will they survive? What is their future?
I think they're going to find a way to survive. I just think they're going to have to adapt a little bit. And I think we're already seeing that in real time. I think we're seeing a lot of these collectives structure as marketing agencies. All right, where basically they buy in athletes' non-exclusive rights, they help them get deals, do appearances, and they give a marketing advance. All right. And then as they make that money back, they make their advance back. So let's say they do a marketing advance of $50,000 with 10 appearances, a bunch of autograph signings, all of these good things. The first $50,000 that comes back in as they get them deals with local restaurants goes to the collective, right? So that allows for sustainability because you're replenishing the funds. All right. And then there's a revenue split after that. I think that's really smart. I think year one, a lot of the conversation has been around inducement. I think year two, a lot of the conversation is going to be around pay for play. You have a lot of these collectives where it's smart to structure this way. But if you don't have someone with a marketing background and a marketing agency background, and they can't actually go and help these athletes get their deals, what happens when you do a marketing advance for $250,000 for a kid that has a couple million followers? And then you look back and they did one bookstore appearance and signed 10 autographs. I mean, that's where the issues are going to come. So when you do it that way too, you're not taking donations. You're really receiving investments because you could turn a profit on this. So if, we've heard Ryan Day say, I need $13 million in the pool at Ohio State yearly. I don't believe that. But Ohio State right now, let's say in their collective, they could raise that 13 million. I don't know if they could do that every year. So how can we find a way to get 8, 9, 10 back in through the advances and making that money back? I think that's sustainable. And then I think you're going to see collectives also have a donation arm where they're bringing in money, where those deals are used to promote local businesses and Shark Tank nights and get real creative. And that's what I think we're starting to see. Now we'll see how it plays out.
I agree with Peter, the way he just described the collectives as businesses that could possibly make money. I think that's the collectives that'll be successful will be set up that way. It's a lot more sustainable than just hoping that 10 boosters will donate $10 million each or whatever that number is every year that can then be used for deals. I think another issue that we haven't talked about yet is some of the nonprofit collectives. I think some of those will probably have some issues if the IRS starts poking around and doing some audits. I just don't see how they could survive. I think almost all of the nonprofit collectives are operating for the benefit of private interests, which you're not allowed to do under the IRS's nonprofit rules. And if the IRS starts auditing some of those, you'll have boosters who receive tax deductions for the money they donated to the collective, then having to pay back taxes, and you'll have some unhappy boosters.
So you're saying paying an athlete to go to the Boys and Girls Club, in fact, isn't a charitable cause? You're still paying for a service and you're paying an athlete to go do something? Shocking.
I do take a little bit of a different approach in looking at the future of collectives. I believe the proof is going to be in the pudding. If those collectives and / programs that are really active in this area start winning a lot of ball games, then this is going to go through the roof. If they're flops, then this could seriously constrict. But it's going to be fascinating. I don't think it's the 2022 season. I think it's a 2023 season that will start to show whether or not this is successful as a strategy.
I guess the only wrench that could be thrown in there is, do we get more legislation? Do we get more enforcement? Are there actual penalties levied? I think that's the one wrench, but I do tend to agree with you, Mike.
Yeah, it's a great point. I'm asked about it by the casual football fan more than anything else. We're getting into the weeds a lot of collectives of NIL, and I think the casual football fan just wants to know, how will this impact football on the field? And I get asked about that all the time. How will this impact the college football landscape? And you see some of the top collectives out there, right? The names of the schools are Texas A&M, Texas, Miami, Tennessee, Nebraska. They all kind of have a similarity, right? USC. They all kind of have a similarity, right? They're all schools that haven't won consistently in a while, haven't won championships in a while, whose boosters are probably super passionate to get back to the top. If they get back to the top, right, you feel like, as Michael said, you feel like, wow, this thing could really get rolling. And all of a sudden, you might have this, oh, NIL works kind of thing, right?
Yeah, I totally
And going back to what Peter said, with the collectives that are sort of acting as marketing agencies, if some of these collectives get really, really good at getting lots of deals for the current players, then they'll just be known as a collective that is able to get lots of deals for their current players, and they're making lots of money off these deals. Then the collectives don't even have to get involved in the recruiting aspect anymore. The coaches will know the deals that the current guys have, and they can talk to the recruits about, hey, this collective does a great job. They get guys lots of deals. This is how much money the quarterback made last year. If you come here, they'll probably try and do the same thing for you. But then they don't have to talk about specific deals, and you kind of get rid of that inducement problem.
Yeah, and I think that's like the importance of disclosures, right? You have to be very careful with university involvement with collectives for liability issues, Title IX issues. So when coaches are on the road, and I was looking at one of the bylaws where it kind of does state that schools can't be facilitators, but that's a whole nother issue. I don't think there's an issue when a kid is speaking with a coach and it's like, look, here's our collective. There was so much in the pool last year. These were the average deal sizes. That you're a quarterback. This is what the quarterback was getting. We can't promise you anything, but if you look at the data, you have an expectation. I think that's totally different than saying we've got this deal for you, or we're going to broker this, or go speak to our collective. And I think the student athletes have to understand their power, that if you know the facts and you know what's in the collective pool, and you know what the average deal size is, and you get there and you feel as if you're not getting a fair share based on your followers play, kind of what was in the pool, you have the power to transfer and tell every other recruit in the nation, and then now good luck at that school, right? And I think one of the issues we're starting to see is you have a lot of collectives who are writing checks that they're what's can't cash. And those collectives that are doing that are going to be a huge issue, and it's going to really negatively impact their universities.
Have you seen that, Michael? Have you seen collectives yet? No, not yet, huh? But do you expect it?
They better not. They better not.
So you get that litigation coming in.
But I think there's a fine line, though, where if you're a coach and you're an athletic department, there's a fine line with the amount of involvement and discussions you have with your collective, which again goes back to the importance of having all of that disclosed. Listen, in my opinion, if you're a collective, you should be doing everything in your power when working with a student athlete who's enrolled to disclose those deals, so you can provide your staff with the data they need to hit the trail and do it the right way.
We're going to go about 5 more minutes and take some questions. We've got about 15 questions in the queue, so we've got some interest here. But let's go 4 or 5 more minutes. Let's talk about. We mentioned it earlier off cameras. The NIL database story came out this morning. Oliver Luck trying to get an NIL database, right? The NCAA was talking about doing this, pooling all NIL deals to create a fair market value of some kind, an NIL database. And after the Alston decision, they threw it out. They realized they can't do it because of privacy and antitrust stuff. So should we have an NIL database? What are your guys' thoughts on this?
I mean, I'll kick it off as someone who runs a disclosure company. I think absolutely it would be important from an athlete protection standpoint as it pertains to knowing what your value is, what's out there, what deals are getting done, am I doing the right deals, to make sure that we understand the space. Also from a legislative standpoint, and really the only way to do that is to gather data. I think the best way for schools to protect themselves is through disclosure. I think the best way to be done is through data sharing. So I don't know if we need necessarily to have a national board where we share every deal, but we can talk about averages, what football is doing compared to other sports, what are some of the gender inequities. The only way we're going to learn and be able to have the space that we want is by understanding the data, not only from the marketplaces, but the deals being done by agents and collectives. So I'm for it. I think there's a value in it. I understand the antitrust issues that can come with it, but I just think if we want to grow as a community, we got to know what's going on, and that's probably the best way to do it.
I think from an athlete perspective, like Peter said, it'd be very helpful for the athletes to know, these types of deals are generally worth X. These types of deals are generally worth Y. So they know what their value is out in the market, and they're not, underselling themselves. But then on the other hand, from, if brands or sponsors or collectives or whoever are using that data to collude and try and drive prices down, then I think that's problematic.
Yeah, I mean, I'll take it a step further. My idea was there should be a national registry board where collectives have to register and kind of put out who's on their board, so we know who's official and who's not. And then going back to what Mike said, I think we need some more realistic regulation that the data will support, which is if kids are talking with collectives, if you take an official visit somewhere, it shows that there's real interest. I think an official visit should trigger your ability to sit down with a collective and learn about the data and the facts. No promises. But again, that also goes with having a national registry and having that data and those facts in there so we understand the data.
Michael, what do you think about deals being out there publicly in a database or filed in a database where you can create some kind of market share or fair market value?
I think the devil's going to be in the details. I have privacy concerns for my clients, and it sounds good, but we don't make other people working in our society put their salaries out to the public.
Right.
So it depends on how we're going to deal with all the privacy issues.
Yeah, Mike, and I should have mentioned earlier, I think there has to be an anonymous aspect to it. I can't say an anonymity, so I'll say an anonymous aspect, even if we're talking about deal averages and stuff like that. But I do agree that it shouldn't be that every deal by Tom or Mary, their name is on it when it gets sent to the NCAA. I do think there's absolute privacy issues there.
Guys, you've all heard of administrators, athletic directors, coaches come out publicly and criticize collectives and criticize the current state of NIL. Unregulated free agency. You hear that a lot because of the transfer portal combined with NIL. And you hear about the pay for play scheme. And then Kentucky coach Mark Stoops just last week called collectives illegal. He thought they were illegal. Can this continue in the current state? You expect it to? And Michael mentioned earlier on this panel that he expects we're here. This is it, and we got to get used to it. Is that what we're looking at?
I think things will be the way they are now for a while. I don't think there's going to be any quick solution. We've talked about, I don't think a federal law is coming anytime soon. I don't think state laws are going to start to be enforced. I don't think collective bargaining is going to happen anytime soon. So I do agree that the current state is going to be the way things are for a number of years at least.
The only disagreement I have there is right now it's just chaotic, and the best way to kind of curtail that is if the NCAA knows or gets wind of there's actual egregious rule breakers out there, if you can levy some punishment and actually put out some infractions, I think you'll see some people maybe pump the brakes. Schools say, wait a minute, let's look at this, and you'll get more uniformity, and the percentage of bad actors will shrink. Now, what size shrinks, I don't know, but I think that's the one thing. If the NCAA comes out and says, look, we're still here, we still have power, you want to sue us, we're not backing down, I think that's the one thing that could slow this thing down a little bit, not fully.
Yeah, I do agree with that.
Go ahead.
Go ahead, Michael.
I just want to say one thing that I really enjoy it when I watch SportsCenter and I see some coach beating up on NIL and then his staff calls me the next day. So I kind of really enjoy that.
Don't name
Shocking.
names.
I'm shocked.
Don't name names, Mike.
No names.
So what is the future of NIL? Lastly, before we get to questions, right? A lot of administrators, a lot of coaches even, right, have realized, hey, NIL is an incremental step to the end. In the end is some kind of smaller, semi-pro college football division, revenue sharing. We talked about it earlier, collective bargaining. Is that where we're headed?
Man, take that. I know this is
I think, like I said earlier, I think we're headed there. The question is what type of model we have and when it happens. One model that I think potentially makes some sense and that people have sketched out, do you sort of move football and maybe men's and women's basketball actually out of the university and they're separate entities that are no longer taking funding from the university to help eliminate some Title IX problems? That's one model. Or are they employees of the conferences, universities? But I think whatever that model is, I think we are headed to a situation where they're employees, there's collective bargaining, there's revenue sharing. It's just a question of when and what model.
Yeah, and I will say on all of that, there is this one little tricky part in Alston that kind of lays out a past case where a national organization in sports tried to collect, there were antitrust issues and they tried to collectively bargain with the players, and the players weren't able to come together. And that created a kind of a little carve out exception, which says, all right, you tried, now go ahead and do what you want to do. So the players have to be careful. I think we're headed towards something though, whether that's a new Division I where they come up with their own rules and then the NCAA enforces it, very similar to what the NFL is. Like, let's be honest, Roger Goodell gets paid all of that money to get punched in the teeth all day. He's not coming up with the rules, the owners are. He's getting paid to be the bad guy. I think that's probably the easier, quickest solution. Your idea of the break off is more complicated. It could be a better one. I don't know. I just want to say, we just have to caution where we're going, because what we don't want to do is ruin what is unique and amazing in America, which is college athletics as a whole. But there has to be a solution where everything's married together and there's a way to do this. I think we're all figuring that out. I think that's the importance of understanding antitrust, employment law, what's happening in the NCAA. And I think all of us on this call have, become pretty acquainted with all that and accustomed to it. And we'll see where it goes.
Well, let me get to some questions, guys, because we have 19 now. I'll try to get to as many as I can. The first one we kind of touched on briefly, but has anyone heard anything about the IRS cracking down on the nonprofit collectives? I mean, it's probably too early, right, to hear about actual crackdowns. That will probably come if that's going to come, it's going to come in the next couple of years, right?
Not yet, but it's coming, or at least you would think it would, based on the way Mitt broke it down.
Yeah, I haven't heard about it yet, but I think this coming tax season we might see some of that.
Well, Mitt, why are they getting approved to begin with?
Did Mitt freeze? I don't think all of them are getting approved. If I'm not wrong, when it comes to filing a 501c3, you could file your intent to be a 501c3. I don't think all of these have been designated 501c3. Not to mention, you can say what you're doing, and then there's a whole nother way in how it's playing out, right? So there's definitely ways to get around that, and I think we're seeing it.
The second question is about agent. What is person asking what agencies or lawyers would you recommend students sign with, i.e., who's good at their job and who's ethically sound? But we have one on the call, so I figured he would recommend himself. Yes, but I don't know. I'm gonna skip past that one. We're gonna let me try to go to some other ones here. This is one of the first ones that was posted in the queue, so let me get to it.
And just while you do that, as people go, just to let people know, Athliance has teamed up with Midwinter and Kennyhertz Perry, his firm, to do some consulting work. So we are working with universities, brands, collectives, agencies that are looking to do anything in the NIL space, looking for any legal help or any consulting work. So please reach out to any of us after this if you are looking for that.
So this is an interesting one, and I certainly don't have an answer. If a company is not based in the U.S., are we aware of any special considerations that the company needs to bear in mind in order to deal with NIL collectives? So an outside of U.S. company coming in and doing deals with collectives, is there anything they need to know?
No, I'll chime in on this and just say, if that pertains to international students, tread lightly. It is not your interpretation of the federal government's visa policies. It's the federal government's interpretation. And the moment you end up in litigation, you've already lost. And what we don't want to see is these student athletes who don't go pro, who try to renew their visas, and then it comes out that they did impermissible deals under it, and they can't stay in the country. So just tread lightly until we have better guidance on that. I don't know if that's what the question was getting at.
Well, and we're going to get that, right? At least that's what I've heard. We're going to get some guidance maybe coming as soon as this fall from the Department of whatever, Homeland Security or whatever that handles that is going to probably, it sounds like, allow NIL deals for international students under passive income, which some of them are already doing that. But I think we're going to get a statement from whoever it is that will release that statement. Hopefully.
Right now, we have a lot of athletes, foreign athletes, who get paid for deals in their country.
Yeah, right. Can collectives or boosters in general work with more than one school? Well, of course, right? Yeah, I can answer that one. Collectives can work with multiple schools, and we're seeing the collectives that are managed by like agency types that Peter mentioned earlier, marketing agencies. Some of them do work with several different schools, I believe. So that is for sure. Collectives
I
can work.
know
with
Life
more than
Wallet
one
and
school.
Paul Ruiz have worked with many athletes at many schools.
Yep. Mm-hmm. That's right. Let's see here. What else we have? Has Peter gotten an NIL deal for his beard? Because it's perfect.
I'm accepting offers.
How about that
Listen, I am accepting offers. If there's any brand on here, just know there's no inducement with me. There's no pay for play issues. I'm a 5'8" white Jewish kid. I'm not playing anywhere, but I will take deals.
I like this question. One answer from each of us. He's asking one answer from each of us to this question. What would you say is the biggest mistake you've seen from a student athlete when it comes to an NIL deal, whether it's signing a deal that has unfavorable language, taking too many deals? And I'll give mine. I was just talking to a University of Tennessee athlete that actually is involved with their collective, the Spire Group. And one of the things he says is, got to learn how to say no. Can't do it all. Too much on my plate. Got to learn when to say no.
Treat yourself like a business. We see a lot of these athletes who are entering into legal agreements and not having anyone with a legal background look over it. Make sure you have lawyers reviewing your contracts and people you trust reviewing your contracts. I think that's one of the biggest mistakes we've seen in this space.
I would second that, what Peter just said. And then I've represented that want to do deal with athletes, and there are a lot of athletes who are very, very bad about getting back to these businesses that want to do deals with them. These are easy deals. Like, they want to put their cartoon character face on a t-shirt. All they have to do is sign the deal, collect royalty payments, and they just don't get back to the company. So I would just say, be responsive if people are trying to give you money. Yes, you have to say no to some deals, but some of these deals are really easy deals that take no time at all. Just get back to people.
Biggest mistake is believing the line, if you come to our school, we'll take care of you on NIL. That's the biggest mistake. And going to a school based on that oral representation.
Next one, do you suspect that individual states will start investigating unlicensed agents operating in the NIL space? We talked about that a little bit earlier, but yeah, do you guys expect that we'll see some investigations into agents that aren't licensed?
Unfortunately, right now, there's no inclination that that's going to happen anywhere. That's a shame. It's almost like these states were so worried that their schools are going to be left behind. They rushed a bill out just to have something on the books. And the only thing that they're concerned about now is, are we at a disadvantage? Do we need to roll back our bill so our schools can be more involved? We hear nothing about the agency stuff, and it's a shame.
I think we might, if there's a situation where an unlicensed agent really screws up a deal really badly and puts an athlete in a really bad situation, you might see whatever state that agent is in do some investigations. But yeah, like Peter said, so far there hasn't been any movement in that area yet.
I hope so. I hope there'll be investigations.
This is a timely question here about some things that transpired over the last few days with the College Football Players Association and Sean Clifford, the quarterback at Penn State. This person just wants to know, what do you think of it? Unionization. I know Mitt, you've been involved with a lot of this and commenting on it. Like, the unionization and that situation, where do you think that's headed, and where is unionization headed, maybe in college football, college sports in general?
Yeah, we've talked about it a few times. I think it's headed in that direction. It's just when and what model we have. But it'll take a lot of time and effort to do that organizing. Like with the Sean Clifford situation, we saw that guys have already kind of started backing out from what they kind of initially had agreed to, and things changed in a few days. So
Yeah, the only thing I'll add there is, do we see like a national union, or does college athletics kind of become like European soccer, where each division, the Big Ten, the SEC, they're all going to have their own unions, they're all going to broker their own deals, and then at the end of the year, we all come together for like a Champions League? I mean, is that the model we go down? And then the other thing that I'm worried about is, I'm afraid we're going to have a lot of people come out of the woodwork trying to be a union rep, trying to make a name for themselves. And we're going to have 50, 60 people fighting to run the union, and that's going to cause chaos in and of itself and hurt the athletes.
So this is an interesting question. This person says they're a student and they're trying to help, I guess, a friend, another student, with NIL deals and social media, basically trying to, it sounds like, be a manager. And they're asking if there's any steps they need to take legally to do this.
Yeah, register with the state.
Yeah, register as an agent. Figure out what's your state law is on registering for an agent and get registered.
Yeah, and if you're 18, 19, 20 years old doing this and you have a legal background, make sure you have a lawyer on staff that can actually help you put together real legal documents, and not only protect the athlete but protect yourself.
Let's take maybe a couple more. This person comments that the conversation we've had revolves around worries that university and collectives should have about all of this. But what are the worries that a student should be worried about when talking with the collective prior to a verbal commitment or a signed letter of intent? So basically, advice for student athletes when negotiating or talking with collectives. Obviously, Michael, you deal with these conversations all the time. Any advice maybe for athletes in conversations or negotiations with collectives?
Don't do it yourself. Have someone else do it.
Or don't do it, but
Yeah. Don't do it yourself. That's my view.
And also, I think the timing is important, as we talked about at the beginning. When are you talking to the collective? Is it before you've committed, after you've signed a national letter of intent, after you're on campus? I think that's important too.
Yeah, and look, just right now, just because the NCAA is not going after athletes, and that's great, doesn't mean that you can't put your university in a precarious spot by doing something that could be deemed an infraction, and all of a sudden, there's loss of scholarship, or your school's getting postseason banned. That will impact you. I don't know if we get there. I think the NCAA would be smart, like we said earlier, to maybe issue some fines just to let them know we're here, don't mess with us. But just know that your actions can impact not only your school, but therefore you once you're on that team.
Do you guys believe that the growth of collectives and maybe threatening schools' finances and donations to schools will increase schools' desire to create their own programs to assist athletes? And some people have mentioned to me collectives coming under the school's umbrella, but that obviously opens up a lot of Title IX issues, right?
Yeah, Title IX issues, liability issues, whether or not that's legal, whether or not if that happens, the NCAA will be okay with it. In a utopian world, could that eventually happen? Maybe. I just think there's so many things that we have to figure out before that's even contemplated for a school to push that envelope.
I think we already are seeing schools sort of bring some of the services that some of the collectives are offering in-house. A lot of schools are hiring people with titles like NIL director or something like that, who in some cases are going out and trying to find deals for the athletes, depending on what state they're in and if their state law allows it, which is what some of the collectives are doing. So I think the schools are trying to figure out ways to bring some of that stuff in-house, if it makes sense.
Two more real quick ones, and they're kind of a similar. What is the realistic percentage for an athlete agent to ask from these NIL deals? We talked about numbers and things earlier, and so just can you guys, what is the percentage that is a normal? Michael, obviously you might know better than all this, but what's the average?
The higher the deal, the lower the percentage should be, is part of it. But I'm seeing all over the place. I'm seeing the 30% guys, the 20% guys, the 15% guys. I personally think anything over 5 to 10% is wrong. Dead wrong. Especially most of these agents aren't doing that much work. They really aren't to get these deals. They're not doing the legal work.
Don't sell yourself short.
No, I'm not an agent. I'm an attorney. Big difference. But what I mean, look, what I'm saying is this, is the typical NIL quote unquote agent who's out there finding deals for these kids. Most of those deals come to the kids. You don't have to shop them around. You really don't have to hustle too hard. The hard part is closing the deal and getting it documented. That's the difficult part. And for just bringing a kid, to meet a company or something, somebody getting 20, 30% is I just think wrong.
The last one I'll kind of hit here is let me find it again. Other well, now I've lost track of things, but there was this one is about, again, a lot of questions on here about students and advice on collectives and dealing with this. And this one asks, are there any, collectives that students should steer away from? Or are there any signs in negotiating with a collective that is like a red flag?
We will take care of you. We will take care of you, and we don't want to put anything in writing.
That seems like an issue, the latter of those. All right. I think we're done, huh? You guys ready to wrap up? That was great. Appreciate all the guests joining. Certainly the panel. That was one of the better NIL panels. I've been on like 20 of them the last few months, and that was one of the better ones I've been on, maybe the best. We've held over 100 participants on here. So that's incredible. So thanks, guests. Thanks panelists. Appreciate it. It's been fun. Until next time.
Thanks, guys.
Thanks, guys. Thanks, Ross.